In this lecture, let's discuss the supportive roles of the professionals in the court. The first one that we'll discuss is the bailiff. First and foremost, the bailiff is indeed a law enforcement officer. He or she is armed as they sit into the courtroom, and their duties are the following. They are responsible for the order in the courtroom. If you have a defendant who literally goes off, then it is their responsibility to protect the judge, to protect the prosecuting attorney, and or the defense attorney or any other individuals in the courtroom. I can remember once a number of years ago when a local jurist sentenced an individual to prison, and as part of the sentence he invoked the Habitual Offender Act, which means that this person had his 5th felony conviction, which in California it is 3 strikes and you're out. In West Virginia it is 5, and that made his sentence a life sentence with mercy, which means he was going to serve an additional 25 years. Upon hearing this, he picked up a chair and threw it with all of his might at the judge, and at that point then the bailiff went into action and secured the individual. And no, the judge was not hurt. This is the individual that you see in the Hollywood scenarios who stands up and says the court will now come to order, and he announces or she announces the entrance of the judge. They will call the witnesses, meaning that they will escort them into the courtroom. In many trials, the witnesses are not allowed to be present during the proceedings, so it is the bailiff who will go out and get them, bring them, escort them into the courtroom. They are also the individual who is responsible for supervising the jury. They will guard the jury, that is, they will stand outside the jury room as they deliberate. They will bring the jury in after the deliberations. They are the individuals who will escort the jury members to, for example, the restroom, and they will also supervise the jury concerning the times when they must be sequestered, meaning that the jury are not allowed to go home. They will be placed in a hotel or motel. They will have all their dinners separate from other individuals in the room. They will not be allowed to have television, read newspapers, etc., talk to each other. During the sequestering, it is the bailiff's responsibility to assure that the sequestering activities do indeed occur. As a general note, bailiffs in the circuit courts for the states tend to be retired police officers or individuals whom the judge knows that is retired, who has law enforcement authority. In the federal system, the bailiffs are going to be the U.S. deputy marshals. The next participant is the court administrator. A number of states utilize this particular professional position. For example, one that is contiguous to West Virginia is Kentucky, and the court administrator will facilitate the running of the court. That is, they will make sure that the judge does not have to do a lot of unnecessary paperwork in the maintenance of running the court in a smooth and efficacious manner. The court reporter, or as your text indicates, it is also the court stenographer, is an extremely important position in the courtroom, because it is this individual who is responsible for writing down every word that is uttered in the courtroom. This is so crucial because, remember, on appeal, the appellate review can only be based on the written record. It is this professional who is then responsible for creating the transcripts that are then sent up to the appellate courts for their review. The clerk of the court is, in the state systems, an elected official. You will have an opportunity to vote for the clerk of the court of our jurisdiction in the next election. Their duties include the maintenance of all records of criminal cases as well as all civil cases. They are also responsible for the maintenance of all verdicts and court orders. They are responsible for preparing the jury pool and issuing the summons to those who they identify as potential jurors. There has been controversy over the years as to where these lists come from. For example, if a clerk of the court will only go to a phone book to find the names of potential jurors, think of all the people who do not have a phone or do not have their number listed. And it may in some instances be related to economics, and that is a land phone is an expensive tool and may not be found in all homes. Therefore, you may specifically eliminate a significant part of the community from being a potential juror. So where they get the list and how they retrieve the list of potential jurors is an extremely important function of this position. It is their responsibility to subpoena witnesses, that is, they prepare the paperwork. While they do not deliver the subpoena, it is their responsibility to create the paperwork for the subpoena. They are involved in the chain of evidence in that it is their responsibility to mark and properly identify all of the evidence that is used in the trial. And it is the clerk of the court who will swear in the witnesses. The use of expert witnesses in criminal trials is quite common. Expert witnesses must be approved by the court. One's credentials are examined both by the prosecutor and the defense. There may be a hearing to determine if indeed the court is going to allow this individual to give expert testimony. It is based on their knowledge and skills in an established profession or technical area. This individual is usually paid to testify. And what makes their testimony so important as to why a defense or prosecuting attorney may attack their credentials is that expert witnesses are indeed allowed to offer opinions, whereas other witnesses are not. Most importantly, they are allowed to draw conclusions from the evidence that they have examined and are giving testimony to. I have qualified as an expert witness in both the state and federal courts and can tell you from personal experience that it can be a very grueling experience in that all of your statements are going to be attacked either by the prosecutor or the defense attorney as you sit in the witness stand and offer your testimony. The categories of non-professional players that you will find in the courtroom drama would be first the non-expert witness, and these witnesses may be categorized in the following. They may offer eyewitness testimony. They may offer character witness testimony, that is, you are allowed to give your experience as you have worked with me as to my character and my moral and my forthright, etc. Would I be the kind of person who would do something like this? And last is, as a victim, your accuser has the right to confront you, so you do not have the right not to testify if requested. And lay witness testimony is very narrowly focused. They can testify as to only what they know, as it relates specifically to the events, activities, or questions that are under examination at that time of the trial. As your book states, Article 3 of our Constitution says that, in essence, we are all eligible and have the right to a jury trial if we so choose, both in criminal and civil matters. Therefore, the next individual who would participate as a non-professional would be the jury member. As the Constitution states, being a jury member is a very basic civil right and responsibility. As I said, all defendants have the right to have their cases heard before a jury of their peers, and it is the accused's choice as to whether they prefer a bench trial, which would be the case heard by the judge, or a jury of their peers. A peer are those individuals chosen at random from the community who represent a cross-section of that community. There has been and continues to be great debate about the use of juries in the American court system. There are issues of their qualifications in terms of intellectually, their ability to follow very sophisticated, complex arguments. And in 1995, as your book suggests, the American Bar Association has released a set of 19 principles that they hope that juries will follow as they are chosen and deliberate. These principles include the proper attention to the needs of juror members. For example, it is an extreme hardship if you are selected to be a juror on a trial that might last 2 or 3 months. Unusual, but it does happen, and you are a working professional. As you can see, this will be very difficult financially. If the juror is sequestered, it would be very difficult physically, emotionally, psychologically. It can be a very difficult situation to be in. Of course, there is going to be the victim, and the Fifth Amendment guarantees that the accused will have the right to confront their accuser. Therefore, these same hardships and more are placed on the victim, because the victim must be present in the courtroom if the accused requests her, that is the defense attorney, requests him or her as a witness. They cannot say no, and therefore must relive their victimization all over again, as well as the inconveniences of the court, meaning that as a witness you will be summoned to be there at 8 in the morning, and you may not be called until late in the afternoon, or you may be told at 5 o'clock to come back the next morning. That is not unusual. If you have a victim, you are going to have the accused, and the accused is the defendant, and in most instances, 99.9% of the time, the accused must be in the courtroom, and of course it is only to their advantage to be so. You can read the role of the defendant in terms of their choices. The non-professional participants in courtrooms would also include the community at large, because we have a right to sit in on all public trials. There is a great controversy concerning the media and their right to be present and what forms of media are going to be allowed. It is my understanding that at this point, cameras and movie cameras are still not allowed in the courtroom, which is why you will see those pictures that are cartoonish in the news as the reporter is making his or her report of the incidents of the trial. The right of reporters, as well as the community at large, would be supported by the Sixth Amendment. In essence, these are public trials, all criminal proceedings. Not to confuse you, but when I stated that cameras were not allowed, that is predominantly in the federal court system, but the state's courts seem to be more lax, and they do generally allow cameras unless there is an exception made by the court. Please know the definition of sequestered as it relates to juries, and read the following cases in terms of jury selection. The first is Barson v. Kentucky. This is a 1986 decision. This attacks the issue that we discussed in terms of the key man approach. The next stage of the trial is the opening statements. Here the order will be always the state or the prosecution, because remember, it is the prosecution who must prove beyond a reasonable doubt that you are guilty as accused. So the prosecution will go first, and in their opening statement they will tell you as a jury why I am guilty and how they are going to prove to you that I am guilty. Following the prosecution will be the defense, and the defense will then say why I am not guilty and how they are going to show that the state's case is not one that meets the beyond a reasonable doubt standard. After the opening statements are completed, the trial will begin in earnest, and here you have the presentation of evidence. And again, it is always the state who goes first. It is the state who must prove you guilty beyond a reasonable doubt. Therefore, they have the burden of proof. The prosecution will then present evidence, which, as your book identifies, is anything useful to a judge or jury in deciding the factual basis of the case. Although that is very generic, evidence has much more of a narrowly focused perspective because of the rules of evidence and procedures, but as a definition, it'll do. Take a look at the different types of evidence. There are three, and I would like for you to be able to define each one. The first is direct evidence. Some examples of direct evidence. The second is circumstantial evidence, what that requires the judge or jury to do. And then third is real evidence. With the advent of forensic science in terms of CSI and other programs, you should know the definition of real evidence. Because evidence is such an important issue in the guilt or innocence decision, the judge will make his or her decision relevant to whether or not the evidence will be allowed to be presented. For example, the evidence that's presented must be relevant to the case or the issue being argued. It must have probative value, which means that it cannot be extremely inflammatory or exaggerated in terms of its horrific qualities. So as well as it cannot be inflammatory, it also then cannot be prejudicial or of a prejudicial nature. Witnesses are a much more qualitative factor in the courtroom as compared to the quantitative factors of material evidence. Testimony, as defined, is the oral evidence presented by witnesses, which would include both the victim, the police officers, defendants, and any expert witnesses. The judge will determine if the witness is competent to give testimony. The witness will be told by the judge that he or she has the right to Fifth Amendment, which means if they are asked a question as a witness and if they answer it, it may involve them in the crime or another crime. They do not have to answer. All witnesses will be subject to both direct and indirect examination. Direct examination is where the prosecutor calls you to give your eyewitness account of what occurred, and then when she is finished, the indirect will be then the defense attorney who is going to attempt to punch holes into the credibility of what you said you saw. This is an important issue to the witnesses, and that is that there is a protection concerning the truth, and that is perjury. Perjury means if you lie under oath and you are caught at it, it is actually a felony. I believe that Mr. Barry Bonds has now been indicted because he lied to a grand jury, and remember, that is the initial stage of the trial process. So as you give testimony, you are placed under oath, and any time you are placed under oath, if you lie, it can then be perjury, and each lie is a different count of perjury. There are a special category of witnesses, and that is children. This is especially true today given the trials involving child molestation. Remember, the Fifth Amendment requires that I have the right to face my accuser. And when my accuser is a 4 or 5-year-old child, or even one who is up to 14 or 15 years old, courtrooms are very intimidating to adults. I have testified in a number of cases over a 12-15 year period. It is something that you just do not get used to, or at least I didn't. In terms of children, I cannot imagine the horror that they would feel as they had to come into the courtroom and be subject to interrogation. Now, both attorneys, defense and prosecution, are very gentle, but still it is an adversarial system. Keep that in mind. So as a way to ameliorate the feelings of intimidation and very great emotional distress to children, and also to give me, as the accused, the right to face my accuser, then courts have come up with the ideas of videotaping their testimony. They will have a judge, prosecutor, defense attorney, and the court reporter, and rather than do it in a courtroom, each side then asks their questions, so you have direct and you have indirect, and all of the responses are videotaped as well as memorialized by the court reporter. And then I like this one as well, and I don't know if West Virginia uses the videotape or this one, which is the closed TV system. And I like this. That is where the child with technology can be placed in a private room. They could even do it in their home now, given the technology advances that we have in this kind of video communication. The child then can give his testimony or her testimony and be responsive to direct and indirect questions, which is live, but the child is just not in the environment of the courtroom. This would be the use of closed circuit TV. You hear this quite a bit, and I would like for you to know what is the hearsay rule. I would like for you to know the definition of hearsay and what and when does the rule apply, and what does the rule prohibit in terms of hearsay. And then I would like for you to know the exceptions to hearsay, and the one that there is a great deal of television scenarios developed around would be, for example, the dying declaration. This would be exception to the hearsay. The idea that as you prepare to meet your maker, you are not going to have lies on your mind. So whatever you say on the deathbed is going to be considered truthful. Spontaneous statements are exceptions. Please read some of the examples given in your text. And out-of-court statements, I would like for you to have some idea and some examples of what out-of-court statements as exceptions to hearsay would be. Moving on, after all the evidence has been presented by both the prosecution and defense, then you have the closing arguments. And of course the closing arguments are a summation or encapsulation of the major highlights of the prosecution. When the defense has his turn or her turn, then it is their highlights of why you are guilty or why not, how the prosecution then proved his point beyond a reasonable doubt, and how your defense attorney proved your case did not meet the beyond a reasonable doubt standard, and the state failed to meet that requirement. In closing arguments, it is the reverse. It is the defense who will go first, and then it is the prosecutor who will follow. So the last argument that you are going to hear regarding the case is going to be from the state or government. After closing arguments have been made, then the judge will give his or her charge to the jury. This is extremely important because this is where the jury is told the laws that they must consider as they deliberate. The judge will tell you what you must consider as part of your deliberations. For example, if it is a murder case, they will tell you what the elements are for first-degree murder, second-degree murder. They will be sure that you understand that you have to have the essential three elements for first degree. If the state did not meet that, then it is a second degree, or it could be not guilty. This is where the judge will tell you, for example, what is the legal definition of beyond a reasonable doubt. And in conclusion, after the specifics are given, charge you. First, there's going to be a foreperson that will be selected. This is the one who is going to coordinate the deliberation. Then the judge is going to charge you, which is the second charge, and that is that you will deliberate, and the third then is going to be you will come back with a verdict. Then the jury will literally physically leave the courtroom. There is a special room that they will go. The door will be closed. The bailiff will present himself or herself outside. No one will enter, and the jurors will not leave unless escorted, and they then begin their deliberations. Deliberations may take a matter of minutes, or it can take as much as several weeks. Many jurisdictions in this country require a unanimous decision to reach a verdict of guilty, meaning that if you have one individual who says in the deliberations, I am not going to change my mind, I have a reasonable doubt, and I am not going to give a guilty verdict, then you will have a hung jury. And the same thing is true for a non-guilty plea. You must have a unanimous decision, a non-guilty verdict. You must have a unanimous decision for both. And as you can imagine, in many instances that can be very difficult to get 12 people to agree on what they heard and saw over a period of time in a manner of a consensus agreement. When you have a jury that is hung, this deadlock then will cause the judge to dismiss the jury. The case then goes back to the prosecutor, and he or she must decide if they are going to retry the individual. Usually they will think of all the time and money and resources they have put in the trial up to this date, and they will say to themselves, do I have any new evidence? Is there any way that I could try this case differently? And if the answer to that is no, then the individual who was accused will be released. Now remember that because the jury did not come up with a verdict, you can be rearrested and retried for the same crime if the prosecutor finds new evidence. It is not a matter of double jeopardy because no verdict was ever issued. This, I think, is why if you are a watcher of court TV and you notice that the defense attorney will just bang on some superfluous or rather non-important issue from your perspective, but they just keep on banging on it. Again, what they are looking for is just getting one individual in that jury to believe that there indeed may be a doubt, and if you can create that beyond a reasonable doubt, then you have in essence won the case, at least in an immediate sense, for your client. There are a number of problems your text discusses concerning the use of a juror or juries in our legal system. For example, jurors in many instances are ignorant, that is, they simply do not know the law and legal procedure. In fact, in some cases, when you get selected to be a potential juror, now you may be struck as a preemptory because you have had a class like this, which means that if the prosecutor or defense sees you as becoming a leader and you will lead against them and you have knowledge of the way the system works, then they are not going to want you in that deliberation room. The only people in that deliberation room are jurors, and therefore, as one who has knowledge of the system, you can exert great influence over the other 11 members. Because you are dealing with human beings, they do have opinions, they are biased, they are prejudicial, and they do not leave that behind as they swear an oath that they will be non-biased or non-prejudicial. And that does affect their subjectivity as they make a decision. Please read the suggested resolution to this problem by some concerning the use of professional juries. As you read that, do you think that's a good idea or not? The last stage, if you are indeed found guilty as accused, then there is going to be a sentencing hearing. Generally, in every state, there must be a pre-sentence investigation done before sentencing. If you are thinking about working as a parole officer, these are good jobs. This is what a lot of your time will be spent doing, and that is the judge will say, I want you to do a PSI on Poffenberger and have it on my desk in the next 35 or 40 days. And you then go out and find out who I am. You will interview the victim or victims. You will interview my family members. You will interview neighbors. You will interview my previous employers. You may ask for a physical or a psychological evaluation, and then you put all of this information together in a narrative report to the court, along with your recommendation as to what should happen to me concerning sentencing. The courts do not have time to go out and do this and get to know the individual, and yet it is the judge who is giving final sentence, so the more information she has, the more just the decision will be, is the thought behind this. Ultimately then, the last stage of the trial process, or I should say the end result of the trial process, if found guilty, is going to be then the sentencing. So after the pre-sentence investigation is done, usually the court, if it is a violent offense or a serious offense, the court will send you to a prison for orientation and evaluation. Here the prison personnel will do the same thing as the parole officer, but they are determining what kind of person you will be behind bars. That is, are you somebody who is going to need a lot of protection? Are you somebody who is aggressive and will probably be a predator? Are you homosexual? Do you have tuberculosis? Do you have AIDS, etc.? All of those things then will go in a narrative report to the court. Come the day for sentencing, the judge will have reviewed both documents and will then make his or her decision based on what the legislature has said that is the requirements for that crime. West Virginia uses the indeterminate sentencing. So, for example, if you have been found guilty of armed robbery, then the minimum amount of time the judge can sentence you to in this state, if it is armed robbery, is 20 years. However, the judge also then has the discretion to sentence you to an additional unlimited amount of years, depending upon what they believe will serve justice at that time. In West Virginia, armed robbery is one of those crimes that can get you the death penalty without really receiving it in a legal form, meaning that the judge can give you 60 years before you are eligible for parole. So you're going to do 20, and you could do as much as 60 before you're eligible for parole. These are called in West Virginia sentences that run wild. It gives the judge a great deal of discretion as he or she then pronounces that sentence. This concludes the lecture on Chapter 8.